Good morning, ladies and gentlemen. This is the briefing session for the October 25th, 2017 Board of Oil, Gas, and Mining hearing. We will go to our director, Mr. Baza. Director Baza.
Thank you, Mr. Chairman, and appreciate the members of the board. Is the microphone on? Okay. I think we've got it working now. So welcome to Salt Lake City for your October board meeting, and certainly appreciated the time we had with board members yesterday as we toured the Compass Minerals operation on the shores of the Great Salt Lake. Kind of a fascinating process they have there, and we certainly appreciate the time that they took in allowing us to come and visit their facilities. Today we're going to start out with a couple of things. Make sure I've got my stuff all in line here. Here we go. As we traditionally do, we introduce new employees with the division at this time. And I haven't looked around me to see who's here, but Kent Phillips. Are you around, Kent? Kent? Just stand there, Kent. So Kent Phillips is working as a reclamation specialist for the Abandoned Mine Reclamation Program. He has a Bachelor of Science degree in geology from Appalachian State University and a master's in mining engineering from Virginia Tech. He's from North Carolina originally, but worked as a consultant in Salt Lake for a few years before returning to graduate school. And after finishing his master's at Virginia Tech, he decided to come back west and do some skiing and climbing in the great state of Utah. So we welcome Kent and want to make sure that he's a familiar face to you from now on.
Welcome.
Secondly, we have Todd Miller. Todd, are you here? Okay. Todd is a range scientist and biologist in the coal program. He's replacing Lisa Reinhardt, who left a couple of months ago. Todd went to school in St. George at Dixie State University, where he graduated with a Bachelor of Science in Biology and a BS in Human Communication. He worked in special education for the Washington County School District and taught at Dixie State for a year. And for the past 2.5 years, he's been working as a partner with the National Park Service and Bureau of Land Management at the Grand Canyon Parashant National Monument in northwest Arizona. So he's living back along the Wasatch Front now, and we welcome Todd to the division. He's already gotten his feet wet. We took a tour this past week of a couple of coal mines in the southern part of the state, so he's learning very quickly. So
Welcome as well.
okay. The next thing on our agenda is to talk about the proposed hearing schedule for 2018, and that's something that Julianne distributed to you last month, and I think there's been a change or two. It affects the January hearing date this coming year and the one in 2019. It looks like both of those hearing dates have been pushed back a week, later in the month. They're still in January, but just late in the month. So
Correct.
okay, and so we'd like to ask the board if you would confirm and validate that and give us your thumbs up that this is the hearing schedule you want to adhere to.
Board members, any comments on that? Then that is approved.
Okay. We have a couple of other items that have come up in the past month, and first of all, we'd like to talk to you a bit about the rulemaking that came under Senate Bill 191. And as you indicated last month at the board hearing, you wanted the division to proceed with an informal process to look at that rule. And I'd like James Owen to talk to you about that, and also a draft letter that he has prepared.
Good morning, Mr. Chairman, members of the board. I've asked...
A little closer to the mic, please.
Is that a little better?
Yes.
Okay, good morning, Mr. Chairman, members of the board. I've asked Julianne to distribute to all of you a copy of the draft letter that will be sent from the division to the informal rules review group. And as John mentioned, this is the division's first step in complying with the order that was given by the board dated the 27th of September this year, based on docket number 2017-013. And this is the solicitation of comments for the rulemaking, the informal rulemaking process that is resulting from Senate Bill 191. My request would be that the members of the board review this draft letter for any changes or modifications you'd like to make, and then this letter will be sent out for comments. We're intending there to be a 60-day comment period, and the comments would be submitted to the division, and then we would move forward with the informal process from there.
Board members, any questions? Okay, we'll look at that and get our comments back to you. Thank you very much.
Thank you very much. Also, we'd like to just give you a couple of updates of things that have happened over the last month. The division belongs to 3 national organizations: the Interstate Oil and Gas Compact Commission, the Interstate Mining Compact Commission, and the Groundwater Protection Council. And for whatever reason, these guys decided they wanted to have all of their meetings in October. So I attended both the Groundwater Protection Council and IOGCC earlier this month. I will be traveling this next week to Washington, D.C. for the Interstate Mining Compact Commission meeting. But I thought I'd just give you a quick understanding of what happened at both GWPC and IOGCC. The Groundwater Protection Council, I think their big thing right now is to address the use of produced water and how it can be improved in terms of its utilization in the United States. And I think I've mentioned to you as a board the role that I've played with the organization in chairing a work group to try to study that and report out the results of that study, that there are opportunities or alternatives for using oil field produced water in the United States. For example, California, I think, has passed some legislation that allows it to be used in the agricultural arena. There's also industrial use that such produced water can be used for. But we did some very good technical sessions and a briefing to the board of GWPC on that topic, and that's one of the things that occurred that really affected me and us as the state of Utah. And I know our legislature is very interested in that as well, as I provided them with a briefing on that during September to tell them what we were up to. And hopefully within the next 18 months, we have a report that will come out of that work group that'll be beneficial for the oil field business in particular, but also for other users of water in the United States. On the IOGCC meeting, some interesting things happened. I think they're touting a resolution that's being pushed by their current chairman, who's Governor Hutchinson of Arkansas, that talks about a process for collaborative federalism and the need for states to assume a lot of the responsibilities that the federal government has been trying to hold for the last decade or so, especially in the area of oil field regulation and land management and other things that affect the oil and gas industry. So he's signing on governors, even as we speak, to participate in that resolution and to make inroads with the federal government in having those discussions with the individual states. So that's a big thing that's going on. IOGCC is also very active in terms of this produced water activity as well. They are also looking at the activity in the United States involving horizontal drilling. They see that as, frankly, the path towards a lot of additional resources in the United States that have yet to be produced. So lots of things going on, both at GWPC and IOGCC. That's just a smattering of what I experienced, and we'll continue to update this board on things that happen with both of those organizations and the IMCC as they occur. But if you have any questions at this time, I'd be happy to answer them.
Board members, any questions? Do you know where our governor is going to be on that resolution?
We've transmitted that resolution to the governor. He has not acted on it as yet, but I know that he's pondering the participation and commitment to that as well.
Okay, thank you very much.
The next thing I'd like to do is John Rogers basically hosted and chaired the Uinta Basin Oil and Gas Collaborative Group this last month, since I wasn't available for that. So I'd like John to take just a few minutes and report out on that meeting.
Okay, go ahead.
Good morning, Chairman Gill and members of the board. As you know, we have our quarterly meeting in the Uinta Basin. We call it the collaborative meeting. It's an opportunity for us to go out and do some education, but it's also an opportunity for people to talk and meet. We have federal officials there, county, interested parties, royalty owners. So it's a good opportunity for us to get together on a quarterly basis and talk about what we do. We hold this meeting at the Duchesne County Event Center. We used to hold this at the Uinta Basin Center there in Vernal, but we found it easier for the people in the Wasatch Front to get to Duchesne, and we find that Duchesne is a good central location, and it's a beautiful facility. And so I'd like to thank, we have two commissioners from Duchesne County here. Appreciate them and their support of this activity, so thank you for that. This last meeting, what we had is we met there, and I decided that I ought to give the overview of what the division does and what we're about. I do this on an annual basis to you, if you recall, early in the year, and we kind of gave that same presentation there so people had a better understanding what the division did, and I thought that was well received. Secondly, we had Dan Jarvis, who is our manager of operations. You know, over the last several years, we've been working on our new database. It went live in June. Obviously, we've been working with it, and there's some tweaks we're still doing with it, but there's interest from the public to see that worked on and have it presented to them live. So I'd encourage all of you to go to our website and look at the data mining tool there. Dan showed us how to use that and showed many people there, and there's a lot of interest there. Thirdly, we had Nathan Hall, who's the new district engineer for DEQ out in the basin. He replaced Scott Hacking, so some of you may know, and he moved to the Price area. But he mainly talked about how spills response are concerned, how we interact with DEQ. And also we had Darren Brown from the Tri-County Health, who is involved in spills out there. So this is kind of an issue when people have an incident, who to call, where to call, and what the criteria are for that. And finally, we had Jordan Mathis, who's the director of Tri-County Health, which covers Uinta, Duchesne, and Daggett County. And there's a new program funded by the legislature called the ULEN program. It's the ability to get an infrared camera on loan from the health department out there to use for mainly small operators to use on site so they can see if they have leaks happening. And these cameras are about $100,000 a piece, so it's something a small operator could not use. So all they have to do is have training and be licensed, and they have this opportunity to use that. So we wanted people to know about that, and we thought that's a good opportunity to get that tool out there to the public. Gordon was there. It's in your backyard, so we appreciate your support. And Carl came out with this, so we appreciate your support in that meeting. And our next meeting will be January 11th. So thank you
very much. Appreciate that.
I might mention in regard to the Oil and Gas Collaborative meeting, John and I often struggle trying to come up with an agenda for that. Things that are both relevant and timely for the oil and gas industry in the Uinta Basin. But I think the next meeting we've kind of decided that we'd like to talk about produced water to some extent. We're hoping to have an industry rep who has been engaged with the industry's energy water initiative for quite a few years come and talk about that. But if you as a board have any topics that you think are appropriate that we should be addressing at that meeting, please let us know, because you know, we try to get ahead of this well in advance of the meeting, but sometimes it's a struggle to come up with presentations and topics that would be beneficial to the industry out there.
John, just speaking for myself, I think anything you can do on produced water to make it useful and beneficial would be a huge gain. Also, I think if there's anything that can be done in terms of what the oil field companies could look at in terms of stock watering ponds and just natural things that they could work with the landowners and wildlife resources, so that you can, sometimes all it takes is just raise the culvert up 12 inches and you've got a pond there that might be available for the 1 or 2 critical months that wildlife or the grazing patterns can use beneficially. So I think that's something that I'd be always interested to see is what we can do. And then the second thing, is there any technology out there that you can use to take some of that? I don't know if it's I heard there was a military in Iraq that they were using some test techniques to see if they could take some of that water and turn it into potable water and just kind of an update where we are on that.
Right.
Is there anything that the board and the division might be able to do?
Well, I think that we're going to rely a lot on this National Produced Water Work Group that we put together to come up with some of those alternatives and opportunities. I think one of the things that we need to consider is, I think people say, well, are you just going to take this produced water and make people drink it or expect that it's going to be put on crops? And I think there's a big cultural barrier there to that, but if we can use produced water and displace the use of fresh water in other systems, I think there's a great opportunity there, because that just creates more fresh water for the rest of us to use. So I think that these types of things will come out in this work group that we're engaged in at this point.
You are to be congratulated for being involved in it, and to the extent it's your idea, even better. So
Okay.
thank you very much.
Thank you.
Members, any other board members have a topic that might be something for the Uinta Basin collaborative meeting? Think about that, and if something comes up, we can talk about that.
Indeed, because we have these quarterly, and if you have any thoughts, we can certainly look out ahead over the next year and see where that would be fit in. A couple more items under other. Last week, we did what was called a deep dive with our Legislative Appropriations Committee, and what was done there is each of the members of the committee was assigned a different agency to spend time with and to go into detail on what their budget was, what their needs were, where they're headed. And in our case, our assigned or designated representative was Representative Duckworth, who is out of Magna. And she was very interested because of her association over the years with Rio Tinto and Kennecott. But it took us a while to get organized with her. There was a couple of times we set up appointments and she had other things come up, but we finally got that taken care of just in front of the interim meeting that happened on Wednesday. I gave a presentation. We had pretty good input and feedback from the committee, and Representative Duckworth did her best to try to support what we're doing at a division level. She did indicate that at least her discussions in the committee are that the general fund money that we've been getting was going to be secure in terms of future years. So we're hopeful of that, because right now oil prices and production still haven't improved to the level that we don't need that money. So that's kind of where we are with that. You're certainly welcome to go look at the hearing yourself. It's been archived on the state legislative website. But it was very quick. Our part of it was only about 10 minutes because they had a number of agencies that they were going through that day. But please feel free to look at that and let me know if you have any questions.
Board members, any questions about that? I just wondered if you could, maybe Julianne, or you could just send us the site website.
I'd be happy to, and I'm also willing to share with you the presentation we gave, and it's entitled Into the Abyss, which was something that Representative Duckworth wanted to title it as. So. Okay.
Thank you.
The last thing I'll bring up under other is I think the chair has asked about an upcoming energy and environment symposium that takes place with the governor's office and the Office of Energy Development on November 8th. And if any of you as board members are interested in participating in that and want to attend, please let either Julianne or Natasha know, and we'll get you registered for that just as quickly as we can. November 8th is a Wednesday, and I believe it's a meeting that starts out about 8:30 in the morning and goes till mid-afternoon.
I just encourage you to consider attending that. I've done it, I think, almost every time, and it's been incredibly informative about energy issues on the downstream side as well as upstream, and really quite worthwhile.
Okay. In terms of next month's agenda and the division calendar, I think you've at least seen a copy of the draft agenda for next month. There are 3 matters that are on the agenda, plus I think we have one that is continued from today that'll be on the agenda as well. And that hearing is on December 6th. Along with that, we've also, I think we've prepared to send out an announcement on our open house that we usually have. And as the board has traditionally done, we're going to do that here in the building on the evening of December 6th from 4 to 6 in the afternoon. So we'll be sending out that announcement and distributing it for people who want to attend that open house as well.
For those of you in the audience, we would encourage you to consider that invitation and to join us for informal get together. It's a lot of fun. The division puts on a really good activity, and it's a way to get to know everyone in kind of a more informal basis. So you're more than welcome to join us. Okay.
So, Mr. Gill, I think the division has completed its briefing for you. I know that there's opportunity for public comment and as well as a special presentation on the agenda. I would be very willing to introduce the presenter at this time, or
why don't we do that? We're going to reverse the order here. We're going, rather than have the public comment, we'd like to have Jeff come forward and Mr. Director, if you'd.
And I think Paul is going to need to get the computer presentation hooked in here real quick.
And board members, while we're getting ready for this, this is the first, we hope, in a series of presentations that will be made to the board about how other states are dealing with horizontal and vertical drilling in their area, how they're dealing with some of the complex issues that are being involved. I would have you note that this presentation is intended to be, like I say, in a series. We also have a issue today, an agenda item number 1, that also talks about this, and we want you to keep this presentation in the context of just informative, but I want to inform you that it is not a part of agenda item number 1 and should be kept separate. I believe the board can do that. With that, Mr. Director, if you'd...
Well, let me go ahead and introduce the presenter today. His name is Jeffrey Lieberman. He's with the law firm of Liskow and Lewis. Is that correct? And he has informed me that the correct place of their business is in Lafayette, Louisiana. So I'll turn the time over to Mr. Lieberman.
Thank you, sir. Chairman Gill, members of the board, good morning. Microphone on?
Just a little closer. You need to, these mics are kind of the...
They're sensitive, huh? Okay, well, Chairman Gill, members of the board, good morning.
Thank you.
My name is Jeffrey Lieberman. I'm an oil and gas attorney practicing out of Lafayette, Louisiana. The board had requested to EP Energy that they give a presentation on just the basics of Louisiana unitization, and in particular, cross-unit drilling in the state of Louisiana. That's my area of practice. I've given this presentation numerous times across the state of Louisiana, so EP asked if I'd be willing to come down here and give that same talk to you, and of course I'm happy to do that, and I greatly appreciate your entertaining this talk as part of your larger series of other states' unitization, and I hope that the information proves useful to you. So I'm a partner with the law firm, excuse me, of Liskow and Lewis. We're one of the older oil and gas firms in the country. We were started in the 1930s, and our attorneys have been handling oil and gas matters and practicing unitization law since the earliest days of Louisiana's conservation statutes. I myself have been doing this for approximately 10 years, and just yesterday, before I boarded the flight to come to your state of Utah, I actually had a hearing before the Louisiana counterpart to your board, the Office of Conservation, in which I myself requested permission to drill, designate, and utilize a pair of cross-unit horizontal wells. Can you help me eliminate my face from this? Thank you. So here's how this general tutorial is going to go. Here's our roadmap for today. Since we're focusing on cross-unit drilling, I'm going to set the table with a brief description of the plays that were involved in the units that existed in North Louisiana, which really gave birth to cross-unit drilling in our state. I'm going to touch briefly on the purposes of unitization and drilling and production units, which I'm sure are the same here in Utah as they are in any state that has statutory or compulsory unitization. And those purposes are important because in the early days of determining how long laterals could be drilled that would be larger than those that could be contained within an adopted drilling and production unit, the Office of Conservation looked at these purposes and looked at various options which would allow these long wells to be drilled and whether they were consistent with the underlying purposes of unitization and the adopted units that already existed. I'll talk about the early discussions and how the ultimate adoption of cross-unit wells was piloted in Louisiana, and finally how the formal requirements that were adopted work and how today cross-unit wells work in Louisiana and how you get them approved. So starting in North Louisiana, by the mid-2000s, the Cotton Valley and Haynesville plays were really in full swing. The units that were created were drilling and production units, and they were 640-acre sectional units. There were over 2,200 created. That's over 1.2.
Jeff, can I just a little more closer to the mic if you can?
Yes, sir.
We record these, and so and this is actually being broadcast live, so
okay,
we need you to be close to the mic.
All right. So the Haynesville and Cotton Valley in North Louisiana, they were unitized on a sectional basis, 640-acre units. There are over 2,200 of them now in place, and that's almost 1.5 million acres that are unitized. The units themselves have 330-acre setbacks, which means that the operator is free to drill the unit well anywhere within the unit so long as it's not closer than 330 feet to the boundaries of the section. The Cotton Valley, and in the early days of the Haynesville, it was developed initially as a vertical play until horizontal drilling was until advances were made in horizontal drilling that would allow horizontal wells completely within the units. But right around 2011, operators were desiring to drill longer laterals, indeed, 1.5-mile laterals that would not fit within the boundaries of the existing and developed sectional units. So these operators approached the Office of Conservation to discuss, would this be possible, and if so, how are we going to do it? The purposes of unitization that exist in Louisiana, which were key in Louisiana's discussions of how we would deal with the long lateral issue, they're really outlined here, and they're twofold. So a drilling and production unit in Louisiana is the maximum area that can be efficiently and economically drained by a well, or as of 2015, the statute was amended to say wells designated to serve the unit, and that was really to recognize the reality that infill wells are necessary a lot of times to really efficiently and economically drain the entirety of the units. But in unitizing, that allows the fewest number of wells to be drilled while protecting correlative rights. So the reservoir is developed in the most efficient and economic manner. And more importantly, each owner gets assurance that they will receive their just and equitable share of the oil and gas from the common reservoir that's been unitized. So equities in production are fixed. The royalty owners know how much royalty they're going to get from production from the unit area. The working interest owners know how much they're going to be charged proportionately for drilling and production and what their net revenues will be. In Louisiana, the bulk of units have production that's shared on a surface acre basis. So the owner of the southwest quarter in a sectional 240 knows that a quarter of the production is going to be attributable to his tract, and he will get his lease royalty times 1/4 of the production from any well that it's producing from the unit. In addressing whether longer laterals, which would go outside the bounds of existing units, would be acceptable, 4 options were considered in light of the efficient and economic development of the previously unitized area, as well as the equities that have been fixed in production and revenue. So the first option was just simply enlarging the units. Let's make them bigger so that the longer laterals fit. The second option was a Band-Aid, or sometimes called a hot dog unit, which creates a smaller overlapping unit in the shape of a Band-Aid or a hot dog bun around the longer lateral, with owners within the hot dog or Band-Aid sharing in production and costs. The third option was a sort of a super unit that overlaid on top of the existing units, and where production costs and revenue were shared on a surface acre basis within the entirety of the overlapped unit for only the long lateral, while the existing units remained in place. And the final and fourth option, which was ultimately adopted, was what Louisiana calls cross-unit wells, which is where the existing units are maintained. The well is drilled across the unit boundaries. It is perforated from both units, and production is shared on a surface acre basis within the existing units on the basis of the amount of overall perforated lateral length in the well that is in that unit, as it bears on the overall perforated lateral length of the entirety of the well. In briefly going through these options, conservation in early discussions simply just rejected, almost out of hand, enlarging the units. This was because it would upset established equities in existing production by diluting the royalty owner's interest, diluting the working interest owner's interests, and if their net revenues were driven down significantly, it would discourage further development of the existing units once they were enlarged. The second option, the Band-Aid or hot dog unit, which was what is done in Arkansas and what was being done at the time, was likewise rejected. Although it didn't upset the equities in existing production, it would exclude acreage in the existing units that weren't in the Band-Aid or the hot dog, cutting them out completely, whereas they would have shared in production and revenue from any other production otherwise coming from the larger units, which remained in place with the hot dog or the Band-Aid overlaying the existing units. Also, there's a possibility that they could take in acreage outside of the existing units and bring in owners who wouldn't share ordinarily in any production from the existing 640s. Super conversion units, super composite units is probably a better way to put it. That was closer to what was going to be ultimately accepted by Louisiana, but it was rejected. It didn't upset existing equities in production, but what conservation was concerned with was if the composite overlaying unit didn't have an equal amount of perforated lateral length in both of the existing sections, that it would be unfair to the owners in the existing smaller section who had fewer perforations or who had more perforations to share in the overall production So if it wasn't 50-50, it was still seen as unfair. Louisiana is a very populous state, so to the extent that existing equities would somehow be shared in a different manner that was ultimately considered unfair by the Office of Conservation, they were unlikely to allow this route. So after many series of discussions with multiple operators, the Office of Conservation agreed to allow a piloting project with the cross-unit wells. And what they did was they required, because it was still something brand new and very controversial, or had the possibility to be very controversial, they required 100% of the interest owners to sign off on it. Anybody who had a working interest, a royalty interest, or was an operator of these existing units had to sign off on the proposal. And that way, if there was no objection, we could go ahead with this project, see if it works, and then ultimately adopt some sort of a formal policy. So the first order was issued in 2011. It was issued on behalf of our client, Encana Oil and Gas USA, Inc., and they had 100% approval of everybody, the royalty owners, the working interest owners, and they operated the 2 units. So they, of course, had their own operator consent. The piloting project, quote unquote, really lasted for about the first 40 to 50 orders, where they were approved by 100% of the owners plus the operators, and they really dealt with cases of 2 640-acre units that were stacked on top of each other with wells proposed to serve both of those units. I'll note at this point that in Louisiana there's an ability to dissolve units if they're created and they're not developed and there's no production for, in general, a year and 90 days. You can come in and have the units terminated. So the cross-unit lateral issue really arose in the context of already developed and produced units. As development went forward, after those first 40 to 50 were done, Conservation finally reduced its policy to writing in this memorandum dated November 2nd, 2012, which you all either have a copy of or will receive a copy of, and that may be the most informative for you. And that sets out the current requirements for cross-unit drilling in Louisiana. And what currently they require is the written approval of 50% of the working interest owners in each unit, so not 100%, and they reduced that to prevent very small minority interest owners from upsetting the whole proposal. But the unit operator's consent is still and always is required, their approval, if they're different, obviously, than the operator of the cross-unit well. Production is allocated on a surface acre basis, as I hinted at earlier, where the proportionate share of the perforated lateral length in each unit is then split. The cost and the revenue from that share is split amongst all of the owners in that particular unit on a surface acre basis. It requires an as-drilled survey to determine what that length is. So once the cross-unit wells are drilled, and there'll be a slide later that shows this, they're required to do an as-drilled survey that shows the top of perforations and the base of perforations. And that way you can determine how much perforated lateral length is in Unit A, how much is in Unit B, and they'll share based on those percentages. Meanwhile, the existing units are not affected at all. Vertical, directional, or short laterals that are contained entirely within the existing units are still shared 100% on a surface acre basis amongst the owners in the existing units. So this slide just sort of illustrates how the working interest approval requirement evolved over time. Originally, the initial orders, the first 40 to 50, required 100% of the owners of the working interest, 100% of the royalty owners, the landowners, plus the unit operator in Unit A, and the same thing in Unit B. Otherwise, the cross-unit well would not be approved. I'll note that units can be created undrilled in Louisiana, and a unit operator is only designated once the initial unit well is actually drilled. So in cases where, let's say Unit B is not drilled, you'd need 100% of the working interest and royalty owners, but there would be no operator. The operator would actually be the cross-unit well operator when it's ultimately drilled. The current requirements as of 2012 require greater than 50% of the working interest owners in Unit A, plus the unit operator. Same thing in Unit B. The requirement for royalty owner consent has been completely eliminated. It proved actually to be not very controversial, and the royalty owners share in the same percentage as they would if those perforations were from an in-unit well, either vertical or horizontal, entirely on their track. So the royalty owners really historically have not had an issue with this. What the working interest ownership sometimes is mistakenly interpreted as, and what it is not, is a composite. So it's not an over 50% in the composite area, but it's an over 50% in each. So this last slide would not work. If you have 90% of the working interest owners in A and 10% in B, that's not sufficient. So here's just a slide illustration. This is the last slide that shows what I've been talking about and how cross-unit wells work. So if we have Unit A and Unit B, an in-unit well in Unit A is split 100% amongst all of the owners in Unit A on a surface acre basis. The purple well in Unit B is split 100% amongst all of the owners on a surface acre basis in Unit B. When the cross-unit well is drilled, the units remain in shape, in their same existing configuration. The well is drilled across the common unit boundary. If the total perforated lateral length in this example is a little over 7,200 feet after the as-drilled survey is performed, if the total amount of perforated lateral length in A is 62.55% and the total amount in B is 38.45%, the owners in Unit A share 100% on a surface acre basis of 62.55% of the production from the cross-unit well, and in Unit B, the owners share on a surface acre basis 100% of the production of 38.45% of production from the cross-unit well. So that sums it up. I know it was fairly dense. I hope it was useful to you. I'm happy to entertain any questions you may have at this time or in the future. And I hope that this will again prove useful to y'all in your survey of the various oil and gas producing states and how they've dealt with the long lateral issue.
Board members, any questions? So on this end, Rich?
One quick question. What sort of setbacks are required for the long lateral if it's being in place near existing vertical wells?
There is no in-unit spacing requirement. So any wells that are drilled to serve the unit, there's no distance requirement. The general field-wide spacing is the general, not field-wide, but the statutory spacing for oil wells is 330 feet from unit boundaries and 900 feet from offset wells. 330 from unit boundaries and 2,000 feet from offset wells for gas wells. But wells within an existing unit, there's no requirement that they be any particular distance from one another at all.
Thanks.
So,
Other questions?
yeah, just continuing with that. So how, were those concerns expressed at times? You know, vertical well, horizontal well, interaction. What?
They were not, and I think in part they were simply avoided by the scheme that was adopted because if I'm the operator of Unit A and I'm also the operator of the cross-unit well, I control where I put any of my wells in Unit A, so I can put them as close or as far from the cross-unit well as I want. If I'm not the operator of Unit A and Unit B is drilling the cross-unit well and he's the operator, he needs my consent, and I'm probably the majority working interest owner, so he needs me to agree to it as well. So I'm approving of his well on the front end. So if later I want to do something that's closer to or would be affected by that well, I already signed off on it and I'm already approving of the plan. So it's too bad for me at that point. Or if I know I have some plans that would be affected by the proposed location, then I can withhold consent or enter into private discussions to change the location to accommodate what I would like to do in my unit.
My question may be a little bit complex, but we have a lateral that is in and out of zone a bit. Is that perforated interval? It looks like it assumes that the entire lateral will be perforated. If there are cases where it's not, how is that handled if that occurs in your state?
In and out of the unitized zone?
Yes.
If a lateral wanders north or south and is perforated either above or below the zone, that's a big problem. The unit would really need to be reconfigured to expand the zone to take in those perforations, or the operator would simply be not allowed to produce the well. If there's non-unitized and unitized production that are being commingled in the same wellbore, that's a big problem in Louisiana. So they would shut that down.
Thank you.
Is there a statute in Louisiana dealing with unitization?
There is.
And
yeah.
is it a requirement, or is it, how does the board authority address that?
The statute in Louisiana is Louisiana Revised Statutes 30:10, and it just provides for the statutory creation of drilling and production units, which is done after public notice and hearing. So I would apply for the creation of a unit and then advertise it for 30 days and appear before the Louisiana Office of Conservation, your counterpart, and try to justify the basis of the unit that I'm asking for, either on a geologic or geographic basis. So the units are created pursuant to that procedure. After that, any party, well, it's really the applicant, has a 1-year preference, but after that, the unit well can be drilled if it's an in-unit well without any further hearings or procedure. You would just permit and drill it. If you wanted to drill additional wells to serve the unit, such as we call them alternate unit wells, but they're infill wells also, you would have to have a hearing to justify why additional wells are needed to efficiently and economically drain the unit. But there is no statutory scheme for these cross-unit wells. It's handled entirely by the commissioner's memorandum internally, just pursuant to the plenary power granted to him to regulate oil and gas in the state of Louisiana.
Well, thank you very much. We certainly appreciate your coming, and I think that's been very informative of one way to look at it. And any lessons learned from your perspective that might benefit us as we start this process of learning more about what other states are doing.
Yeah, absolutely. And again, this is just Louisiana's perspective and Louisiana's thought process in doing it. So,
okay, thank you very much.
well, thank you all.
Yeah, one more question.
Do you, as a lawyer, work outside of Louisiana and have experience of what goes on outside of Louisiana?
I'm not admitted to practice outside of Louisiana, but I'm familiar with how these issues are handled in Texas and Arkansas and other states. But no, I'm speaking to you as a Louisiana attorney on Louisiana law at all.
Thank you.
Thank you very much. At this time, we're going to turn to the public. If you have a issue you would like to discuss with the board, we'd invite you to come forward. If you're a county commissioner, we'd especially invite you to come forward and talk to us about any emerging issues or concerns you might have. If you want to stand up, that's fine. Come forward to the mic. Seeing none, then we will be adjourned till 9 a.m. Thank you. I beg your pardon, till 10 a.m. 10 a.m.